He has a significant criminal history with 15 felonies, 9 misdemeanors. He's been to jail 10 times, prison 9 times, probation 4 times.
The court's obviously aware of his record, and it's not a great record. It's a terrible record.
I can assure you, Mr. McRum, if I had habitual third or habitual fourth in front of me today, your prison sentence would be long enough it might take your breath away.
In Sheboygan County, Michigan, Brandon McRum appeared before Judge Aaron Gauthier for sentencing on a charge of operating while intoxicated, third offense, habitual second. The defense arrived with a comprehensive sentencing memorandum that went far beyond a standard mitigation argument built around adverse childhood experiences. It was a scientifically documented framework examining how early trauma shapes long-term behavior and substance abuse. The prosecution had a criminal record that spoke for itself. Judge Gauthier had the pre-sentence investigation, the guidelines, and both sides ready to be heard. What happened next was not going to be a straightforward sentencing hearing.
State of Michigan versus Brandon McRum. It's filed 26-7126FH. Counsel, you want to state your appearances beginning with people?
Good morning. May it please the court, Michael Comorn appearing on behalf of Mr. McRum. This is to my immediate right. State your name for the record, sir.
Brandon McRum.
Okay, good morning. And Mr. Comorn, have you had a chance to review the pre-sentence report with your client?
I have, Your Honor.
Any additions, corrections, or modifications to the content?
There were no deletions, edits, or corrections that need to be made.
Okay. The advisory guidelines have been scored at 10 to 28 months on a charge of operating while intoxicated third, habitual second. Do you have any scoring challenges?
We do not.
Ms. Goodrich, do the people have any additions, corrections, or scoring challenges?
No, Your Honor.
Okay, Mr. Comorn, anything you want to say on behalf of your client? Go ahead.
Yes, Judge. We put together a pretty comprehensive, or tried to put together a comprehensive sentencing memorandum, which I think covered most of the stuff. I'm not going to repeat all that. I'm going to try to summarize the important points I think are extremely important for the court's consideration in issuing its sentence. What I think is important and matters most, and I ask the court to weigh, and when selecting, is obviously we start with the guidelines, which are 10 to 28 months. My client did plead guilty. He didn't put the people to the proofs. He didn't litigate the stop. He didn't litigate the field test. He acknowledged what he did and accepted the consequences of his conduct. This is important for Michigan's proportionality framework under Steenhouse and commands attention to the offender, not just the offense. The offender before this court did not have to be dragged into accountability. He walked into it. The statements to the pre-sentence investigators are not statements about getting caught. They're statements about the harm he could have caused other people. That is the language of remorse, and it's corroborated by what he has been doing inside the Sheboygan County Jail since October of 2025, which is consistent attendance to Alcoholics Anonymous, consistent attendance to Celebrate Recovery, and unprompted self-directed engagement with the recovery materials. The attendance logs are before the court, and the PSI confirms that he has been thoroughly engaged. I want to be candid, however, because the court's obviously aware of his record, and it's not a great record. It's a terrible record, in fact, and I'm not going to try to pretend otherwise. He's got a long history of alcohol and drug-related offenses, many involving driving, but all circling around with his substance abuse issues that have been a long-standing problem for him. I know the court has recently had him as a defendant as early as 2020 and was a sentence which he was done and then was on parole when he picked up this new case. His convictions stretch back across decades. He has been to prison, and as I mentioned, he's on parole when this offense happened. But what we're submitting to the court and respectfully ask the court to consider is that just that there needs to be some kind of different approach to these particular types of situations, especially in Mr. McRum's circumstance. There's been thousands of days of incarceration that he's already participated in. The Compass assessment from his 2020 PSI identified the exact same core criminogenic needs. The system has named this problem repeatedly, and unfortunately, it has not been resolved and it continues to exist. So what is the underlying driver that seems to be the force in Mr. McRum's life? What I'm suggesting, and ask the court to likewise find that this all goes to the heart of the mitigation. This substance abuse disorder that Mr. McRum has was not developed in adulthood. He developed it as a child in a home shaped by parental alcoholism and chronic conflict between his parents. The environment by itself is documented in the clinical literature as significant adverse childhood experiences that is only part of the picture. When Mr. McRum was 5 or 6 years old, he was also sexually molested by an older cousin, a teenager, 15, 16 years old, over a period of several months one summer. He has reported that abuse consistently and across 3 separate pre-sentence investigations, spanning 15 years from 2011, 2020, and again, at this last PSI that was prepared. The agent in the 2020 PSI specifically recorded that Mr. McRum identified that abuse as a trigger for his continued alcohol use and criminal behavior. And this is not a strategic, convenient disclosure made on the eve of sentencing. It's been something that's been consistent within his pre-sentence report, something that he's reported and is identified when exploring his issues over and over again over a long period of time. He began drinking at the age of 8, and by 17 or 18 was drinking heavily. That's not a recreational pattern. That's a child medicating pain he had no language for and no tools to address. Next is that the history and what brought Mr. McRum to this court is not just advocacy or elocution. It's established science and has been recognized within the federal court system. The adverse childhood experience studies published by, and I mentioned all this in my memorandum, Felini and colleagues in the American Journal of Preventive Medicine, as far back as 1998, established a dose-response relationship between childhood trauma and adult substance use disorders. Mr. McRum experienced multiple categories of those adverse experiences, both parental alcoholism and childhood abuse. The Substance Abuse and Mental Health Services Administration, in its treatment improvement protocols number 57, has documented how that early trauma alters the developing brain, the stress response system, the prefrontal cortex, the very neurological architecture of impulse control. The National Institute on Drug Abuse classifies addiction as chronic, relapsing brain disease that frequently reports multiple treatment episodes. Also referenced in our memo is Dr. Kanzian's self-medication hypothesis published in the Harvard Review of Psychiatry, describes precisely the pattern documented in Mr. McRum's life. Substance used to numb the unbearable. This is not novel science. It's not defense theory invented for the court. This is the Sixth Circuit holding in Hodge versus Clappett, 136 F 4th, 648, 2025, expressly recognizing that the established links between the effects of childhood trauma and long-term psychiatric and behavioral difficulties, including criminality. The Second Circuit in Sawyer, U.S. versus Sawyer and U.S. versus Caesar has recognized that extreme childhood abuse contributing to the offense may warrant a lower sentence. I'm not asking the court to import federal sentencing doctrine into Michigan law. I'm asking the court to recognize that the mainstream judicial concept here that documented childhood trauma matters at sentencing fits squarely within Michigan's proportionate framework under Milborn and Steenhouse. Proportionality requires attention to the offender, not just the offense. The offender before this court is a man whose severe substance use disorder is rooted in documented childhood sexual abuse and parental alcoholism trauma that has never been treated. During his periods of incarceration, he has done some treatment. He's completed a remarkable amount of programming. The 2020 PSI documented an extraordinary array of it. He engages, he participates. What has been missing is the continuity of care directed at the root cause rather than the surface symptoms. We're not asking the court, Your Honor, to ignore the record or the history of Mr. McRum's crimes that he's pled guilty to. We're just asking to recognize that when you look at the number of convictions and a man who's, but as he stands here today, if we're really looking at trying to be, following the guidance of our courts in terms of, I'm not making excuses for him. He's pleading guilty. He knows what his liability is. He knows he's going back to prison under parole violation, Judge. The guidelines are, the recommendation of the PSI is, I believe, 2 years to 5 years. He doesn't get any credit, obviously, because he's on parole. I'd ask you to consider that as well. But Judge, we're asking the court sentence that will address these concerns that I raised and not just send him back and expect change from him just going to prison. I'm asking the court's got this case before. I don't know that there was ever an active case in Michigan that resulted in a conviction and placement on the registry. It seems obviously it's from something in 1996.
Yeah, in 1996, Ohio, I think it was an offense that the 2011 would have been a recapture provision.
Right.
And I think I probably, I don't recall, but in 2020, I probably said what I'm about to say now, that, it seems like, maybe he shouldn't even be on it, but he'd have to petition. I think there are some statutory mechanisms for him to petition for that. I don't know that in this OWI case, I have any jurisdiction to address his registration or not. This offense is not affecting his registration. But that may be something that he may want to consider filing, either a motion under the statute or some kind of declaratory action, or I don't know.
I told him I would raise it. We discussed it. I told him the same thing you told him, which he shouldn't be on it. And we just got to get it the right.
Yeah, I think I tend to agree that he shouldn't be on it. I don't know all the facts and circumstances. I can't make that ruling, but I'm sympathetic to that position. But I think he'd have to file a motion in the appropriate case or appropriate mechanism.
I think you're right. It was a recapture from it. So just for purposes of it, and I know you're set before you right now, but it seems to arise out of the
2011 recapture. Yeah. The 2011 FTD, been a recapture of the 1996.
Okay, right. So that would be the case number he would have to.
I think so.
Okay.
I think so. And would have several arguments, one of which that the recapture provisions would be unconstitutional ex post facto, now that the Supreme Court and Court of Appeals have held that SOAR is punitive.
All right. Thanks for clarifying. And I have nothing else to say. So thank you for your time.
All right. Thank you. Mr. McRum, you don't have to say anything today, but you are more than welcome to. Is there anything you want to tell me or no?
Want to say I was doing very well, and I was a little more proud of myself than I've been in many years. I came to a point in my recovery where I thought I could do it on my own, and ended up being another worst mistake I could have made. And I'm grateful that in all of the decisions I made that I've never physically hurt anybody. No, it's a risk that God is my witness that I'll never take again.
All right. Thank you, sir. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. On October 16th of 2025 at 2:35 a.m., the defendant was swerving across the center line and the fault line and speeding 60 miles per hour in a 35 mile per hour zone. He had a .146 blood result. He is now 48 years old. He was 19 years old at the time of his first arrest. He is currently on parole for the same OWI third offense. He has a significant criminal history with 15 felonies, 9 misdemeanors. He's been to jail 10 times, prison 9 times, probation 4 times, and 1 time he absconded on parole. OWI is endangered the community, and he's also committed victim crimes, the 2000 larceny, 2001 theft, 2003 theft, 2011 illegal sale use of property, 2018 unauthorized use of property, 2019 attempt to commit B&E, 2019 burglary and receiving stolen property, and 2020 receiving and concealing stolen property. He's also exhibited an inability to follow the rules and listen to law enforcement in 1996. In 1999, he failed to obey a police order. 2005, disorderly conduct that was reduced from false information to a police officer. In 2005, he was convicted of escape. And then we get to the OWI related convictions in 1999, 2003, 2007, 2011, 2013, and in 2020. He does not appear to do well on probation or parole. His 2011 conviction of OWI third, he was granted parole on June 25th of 2013. He was held under custody 3 months later. And on January of 2014, he had a new prison commitment for his Emmett County OWI third. In 2020, he was convicted here in Sheboygan, has been discussed. He was granted parole October 23rd of 2024. He absconded from parole June 9th of 2025. He was returned to the MDOC on July 22nd of 2025. He had changed his residence without permission. He had consumed alcohol on June 7th, 2025. He failed to comply with substance abuse programming. He failed to successfully complete halfway house program. He failed to report to the field agent. He had used a vehicle without the vehicle owner's permission on June 11th of 2025. He operated a motor vehicle without a license. He drove a motor vehicle without permission of the field agent, and then violated the criminal law by providing false information to law enforcement on July 11th, 2025. On August 26th of 2025, he was reinstated parole. And then on October 16th of 2025, he committed this OWI third and has remained in jail since that time. A lot of services have already been tried: inpatient, outpatient, AA, NA meetings, MDOC programs. The defendant has exhausted all resources. He continues to make decisions that endanger the community when he is part of the community, and leaves the court as a result with no choice but to remove him from the community and sentence him to the maximum amount of incarceration allowed. Thank you.
Well, thank you, Mr. McRum. If you please stand for the court sentence. You know, your attorney gave a lot of detailed information, Mr. McRum, about, you know, your past, and some of the things that have happened in your life have flowed into your life as a result of your choices. Some of them have flowed into your life not as a result of choices of your own, and you've suffered some negative consequences from some of those traumatic experiences. The court knows that full well. You know, I preside over a treatment court program. I'm well aware of the interaction between adverse childhood experiences and childhood trauma and substance abuse and criminality. You know, I'm generally supportive of treatment options whenever they're available. You know, in this case, as the prosecutor outlined, there's been several attempts at treatment in the past, and you know, most recently I see it in the PSI. Yeah, while you were on parole, you went to the Volunteers of America residential program in 2025, a residential treatment program with therapists individually and group therapy. And then you voluntarily left that program, I think, and then that's when you would have absconded parole supervision. So, I mean, you know, when treatment's been extended to you, you know, when you abscond and remove yourself from it, you know, that matters. The prosecutor outlined some of your criminal history. It is fairly remarkable. You've got the short prison sentence in 1996 out of Ohio for that attempted abduction. Then in 1999, you get your first DUI in Ohio. So that was, you know, over 27 years ago, you get your first DUI. A couple thefts in Ohio in the early 2000s. 2003, you get a DUI in Ohio, you go to prison. That's your second one. 2005, you have an escape charge or escape conviction out of Ohio. 2007, an OUIL in Ohio. That's your third OUIL. Again, you go to prison. Then you are in Michigan. In 2011, you get your fourth drunk driving conviction out of Sheboygan. You go to prison, looks like for 2 years. In 2003, when you're on parole for that OWI third, this is an important feature. When you're on parole for OWI third, you commit another OWI third. That's your fifth one in Emmett County, and you go to prison for 3 years. After you're paroled, you're back in Ohio. There's some misdemeanors, then a 2019 burglary, and you're back up here in Sheboygan in 2020. We meet, and you're on a OWI third habitual second, which is what you're being sentenced for today as well. It's your sixth OWI conviction, but Michigan caps it at, you know, third or subsequent. And I give you 4 years in prison. You're paroled in October 2024. You abscond that parole in June of 2025. You're caught in July, re-paroled in August of 2025. And by October of 2025, you drunk drive again. This is your seventh one that now I'm sentencing you for while you're on parole for OWI third. So I'm a little confused about when you said you're proud of how well you were doing. I don't know what period you're talking about, because you're on parole for OWI 3, you abscond parole supervision, leave treatment, and catch a new OWI 3 charge while you're on parole for OWI 3. I don't know what period you're talking about where you were doing well, because I don't see anything other than maybe 6-7 month period from the tail end of October 2024 into June of 2025, maybe, if that's what you're talking about. But that's really a remarkable criminal history that shows essentially nonstop criminality, committing crimes while on parole. In fact, committing while on parole the same crime for which you're on parole. Your seventh OWI felony. Guidelines do not adequately take into account the fact that you continue to commit the same crime, and that twice in your life, while on parole for felony repeat drunk driving, you've committed another felony repeat drunk driving. This is the second time you've done it. I gave you 4 years in prison in 2020, and while you're on parole for that, you commit the same offense. I can't see how I possibly give you any less. Should be more. And I think if your lawyer's done a great job by getting you a resolution of at the same level, the habitual second. I can assure you, Mr. McRum, if I had habitual third or habitual fourth in front of me today, your prison sentence would be long enough, it might take your breath away. The maximum that I can do under the Tanner 2/3 rule is a 5-year maximum, increasing the statutory max to 7.5. And I'm going to do that. I think that's certainly called for. It is an upward departure. The remarkable drunk driving history, the remarkable history of committing the same offense while you're on parole calls for that 2/3 Tanner maximum. So, Mr. McRum, I'm going to commit you to the Michigan Department of Corrections for not less than 5 years, nor more than 7.5 years. Again, exercising my discretion to increase the statutory max of the habitual statute. You get credit for 0 days served because there's the parole detainer, and this is mandatory consecutive to the parole violation. I believe it's proportionate to the circumstances of the offense and the offender. You can file an appeal if you wish to the Court of Appeals. If you want a lawyer, we'd appoint one for you. If you qualify, you'd have to make that request within 6 months. We're going to hand you a piece of paper explaining those appeal rights, ask you to initial one copy so we have a record we gave it to you. The other one is for you to fill out if you wish to take an appeal. $130 mandatory crime victims assessment, $68 state costs, a mandatory minimum fine of $500. There's a $367.19 OUIL reimbursement, and the court will impose court costs of $350, which is well short of the average cost per case as calculated by the State Court Administrator's Office. All right, thank you.
In Michigan, an upward departure from sentencing guidelines requires the court to justify on the record why the standard range falls short, and that justification now follows McRum into every future proceeding. The sentence runs mandatory consecutive to his parole violation, meaning it does not begin until that violation time is fully served with 0 jail credit applied. The habitual second offender designation pushed the statutory maximum to 7.5 years under Michigan's 2/3 rule. Any post-release control violation can return him to prison for up to half of the original sentence. On top of incarceration, McRum faces mandatory fines, state costs, crime victims assessment, and OWI reimbursement totaling over $1,400. A 7th drunk driving conviction while on parole for the same offense means the record walking into any future Michigan courtroom just got significantly heavier. If you think the defense had a strong enough argument to justify a sentence within the guidelines, drop your thoughts in the comments and subscribe for more cases like this one.